Welcome to the Explainer. Today, I am absolutely thrilled to step into the role of your professor and take you through a high-energy masterclass on the legal bedrock of trusts, looking specifically at the Zambian context. If you've ever wondered how the ultra-wealthy protect their assets, or how a simple, seemingly innocent legal phrase can either secure a family's future or just completely tear it apart in court, you are absolutely in the right place. We're going to decode the legal DNA of trusts, step by step, to make these really complex, equitable principles crystal clear.
Okay, let's dive right into our syllabus for today. First, Zambian statutory authority. Second, the types of trusts. Third, certainty of intention. Fourth, certainty of subject matter. And finally, number 5, certainty of objects. Kicking things off with Section 1, Zambian statutory authority.
So to actually legally ground the creation and administration of trusts in Zambia, we have to look to 3 really critical pieces of legislation. First up, we've got the Land or Perpetual Succession Act, Chapter 186. This is the one that allows a trust to be created, incorporated, and then actually own real property in its own name. Second is the Trusts Restriction Act, Chapter 63, which, well, true to its name, puts parameters and restrictions on the creation of settlements and future interests. And third, the Administration of Estates, specifically the Trust Corporations Act, Chapter 62, which enables corporate bodies to step in and act as executors and administrators. Together, these 3 statutes literally form the legislative backbone of Zambian trust law. Moving right along to Section 2, the types of trusts.
Now, what's really interesting when you look at the entire trust universe is how it cleanly splits into 2 main branches, private trusts and purpose trusts. Purpose trusts are created for exactly that, a specific purpose, like a charitable goal, rather than for specific people. But on the other side, we have private trusts, and these are created for ascertained specific beneficiaries. Under private trusts, you'll find express trusts, which are intentionally created by a settlor, alongside resulting and constructive trusts, which are actually imposed by operation of law or presumed intention. Now, for the rest of this explainer, we are going to focus entirely on that first category, the express private trust.
Which brings us to the deep dive. Section 3, the core framework, certainty of intention.
So certainty of intention simply means it must be abundantly clear that the settlor, that's the person creating the trust, genuinely intended to create it. Now, what's fascinating here is that there is literally no magic set of words required. You don't even have to use the word trust. As the fundamental legal maxim states, equity looks to the substance rather than the form. The courts are basically looking for genuine intent. They peer right past the surface language to figure out what the settlor actually meant to do.
But having said that, words do matter, and we have to compare them carefully. First, we have precatory words. Precatory words are basically expressions of hope, desire, or belief. Think of phrases like "in full confidence" or "it is my wish." The general rule here, and we see this in the famous case of Rhee Adams and the Kensington Vestry, is that precatory words usually fail to create a trust. They're just requests, right? To successfully create a trust, you need imperative words. That's language that imposes a mandatory, absolute obligation on the person holding the property.
Okay, let's take this out of the theoretical and into a real-world scenario. What if someone uses the perfect imperative words, executes a flawless formal trust document, but then hides that document in a safe and proceeds to use the supposedly trusted house to secure a personal bank loan? Does the mere existence of a piece of paper guarantee legal intent? Well, this isn't just theory. This is exactly what happened with Mr. Musoka in the case of Midland Bank versus Wyatt. When his business went under, he suddenly pulled this trust deed out of the safe to try and stop creditors from taking his house. No way, right?
And this brilliantly illustrates exactly how courts ascertain true intention. The court looked at Mr. Musoka's actions and declared the trust a total sham. It was voidable. They look at where the precatory words were used, they acknowledge that the word trust itself isn't definitive without genuine intent, and most importantly, they heavily evaluate the settlor's conduct. Your actions absolutely have to match your words. Conduct alone can sometimes prove or completely disprove a genuine intention to create a trust. Let's hit Section 4, certainty of subject matter.
I want to clearly break down the subject matter rule for you, because it's actually made up of 2 distinct subcomponents. First, you need certainty of property, meaning the actual physical assets or funds must be clearly identifiable. Second, you need certainty of beneficial interest, meaning you must know exactly what specific share of that property each beneficiary is actually entitled to. You absolutely need both of these to survive the test.
Let's look at how certainty of property can fail. Check out this quote from a case way back in 1854, Palmer versus Simmons, "The bulk of my residuary estate." Now, it sounds generous, doesn't it? But legally speaking, it's a total disaster. I mean, what exactly is the bulk? Is it 51%? Is it 90%? Because this vague language makes it literally impossible for a trustee or a court to identify the exact property. The certainty of property is ruined, and the trust fails entirely. Now let's look at that second subcomponent, beneficial interest, by comparing two very different outcomes. In Boyce versus Boyce, a testator left houses to his daughters, stipulating that one daughter got whichever she may choose and the other got the remainder. But here's the catch. The first daughter died before making a choice. Because that vital choice was never made, the second daughter's interest became completely uncertain, so the trust failed. Contrast that with Rigolet's trust, where the testator directed a beneficiary to receive a reasonable income. Now you might be thinking, reasonable, that's super vague. But the courts actually allowed it, ruling that they could objectively assess what constitutes a reasonable income based on the beneficiary's previous standard of living.
Moving into the final stretch here, Section 5, Certainty of Objects.
So, the crucial point here is that the test the court uses depends entirely on the type of trust you have. If you've got a fixed trust where everyone gets a set, defined share, the test is strict. It's called class ascertainability. The trustees must be able to compile a complete, comprehensive list of every single beneficiary. But if you have a discretionary trust, where trustees have the power to choose who gets what from a defined group, the test is a bit more flexible, individual ascertainability. Here, you don't need a complete list. You just need to be able to say with absolute certainty whether any given individual who walks through the door is or is not a member of the class.
But wait, even if you know which test applies, there are traps waiting for you. Here are the three massive pitfalls that can render your objects uncertain and completely destroy your trust. First up, conceptual uncertainty. That's when your descriptive language is just too vague. Second, evidential uncertainty, when the concept itself is clear, but you just lack the records or proof to actually identify the people. And third, administrative unworkability, where the definition is crystal clear, but the class of people is just too ridiculously massive for a trustee to ever manage. Let's break those down a bit, starting with conceptual uncertainty. Take a look at this. If a settlor creates a trust for their friends, the law actually considers this legally void and uncertain. I mean, how do you legally define a friend? Is it a lifelong companion or just a guy you play golf with twice a year? The court is not going to guess for you. However, words like relatives or dependents are legally accepted and valid, because the law has strict objective definitions for blood relations and financial dependency.
But hey, there is always a fascinating loophole in equity. You can actually bypass the conceptual uncertainty of the word friends if the settlor provides a highly specific dictionary or list for the trustee to use. For instance, if a trust says, "To my trustee to hold on trust for my Facebook friends," the court might actually save it. Why? Because the settlor provided a concrete, objective digital list. A person is either on that digital friends list or they aren't. Boom, certainty is achieved.
Let's see how this builds into our final pitfall. Administrative unworkability. Imagine a settlor leaves money in a discretionary trust for all the residents of Greater London. Conceptually, it's perfect. We know exactly what a resident of London is. Evidentially, it's fine. We can just check census data and addresses. But administratively, it is an absolute nightmare. A trustee cannot realistically manage a discretionary class of literally millions of people. The court will strike the trust down because it is practically unworkable.
Which brings us to the end of our masterclass, and I want to leave you with this final provocative question. If you drafted a family trust today, right now, would your choice of words survive the harsh test of the three certainties? Would your intention be undeniable, your property unmistakably defined, and your beneficiaries perfectly identifiable? You see, the law of trusts demands precision. It protects assets powerfully, for sure, but only for those who play by its rigorous rules. I really hope this explainer has given you a newfound appreciation for the incredible precision required in legal drafting and leaves you eager to explore even more about asset protection and the completely fascinating world of equity.